Oh, there we go now. I guess it didn't do it. All right, then continuing with open announcements, Mr. Schmidt.
Judge, continuing from yesterday, Kenny Gillian is in the hall, but he's wearing long shorts. He's the one who took the drug test, sat in the courtroom. I had left, and then he left, and he ordered me back today when I walked in. So, could he come in with the shorts so we can arrest him?
Sure.
Thanks.
Do you have a? I was going to ask, do you have a reset notice or just a copy of one?
From yesterday?
No, just any reset notice. Just need any reset notice. All right, this is back on the record in cause number CR 21-0353-173, the state of Texas versus Kenny Gillian. Mr. Gillian was ordered to take a drug test yesterday. He took a test and it appears as though he is positive for methamphetamine and THC and admitted to possibly using ecstasy on July the 12th at a party. And then Mr. Gillian did not come back to court after the court specifically instructed him, when you get done with the test, come back in the courtroom and we will go over the results together. I say it 100 times a week, it feels like.
Yes, sir. I apologize for that.
And then, Mr. Gillian, you showed up today. Did you get a reset notice from yesterday?
No, sir.
You didn't? Well, it's because you left. Well, no, you would have got one.
He did.
And so you didn't with the
That piece of
date?
paper I gave you? Right.
Oh, yes. Yes.
Right,
I'm
and
sorry.
then you probably got one back in the last time. we
No,
had
it was our
court.
first thing.
Oh, it was
We
the first
filed a
thing?
waiver.
Well, if you'll look on there, it says dress code. Do you see that?
Yes, sir.
And can you, where's it at? I can't even, oh, the first one, we're right under you will not be allowed. Can you read that for me?
Sir, it says shorts or pajamas.
Or what? Read the line above it.
You will not be allowed to enter the courtroom if
With
you are wearing shorts or pajamas.
Yeah, say that loud
Sir.
once you see it. All right,
Apologize.
so you're in shorts, you
Yeah.
left. But Mr. Schmidt told me he had a conversation with you and you might have misunderstood. So now that there's no misunderstanding,
Yes, sir.
your next court date is
It was August 11th.
Yes.
August 11th at 1:30, no shorts.
Yes, sir.
And we haven't placed conditions of bond on him. Now that you have tested positive, I'm a second chance kind of guy, Mr. Gillian. So I'm placing conditions of bond on you. There's going to be no alcohol, no illegal or controlled substances not prescribed, and no THC or marijuana in any form or fashion. Okay, sir?
Yes, sir.
So as soon as you get that, you're free to go.
All right.
And just make sure you stay in touch with your bondsman and your attorney, and we'll see you in August.
All right,
Does
sir.
he need to sign or anything? You order it. How's that work?
He just needs to sign it.
Okay, sign here.
Oh, and I will recall the request for a capias and rescind the bond.
Thank you, Judge. Sign it there. Needed to see session.
Yes, sir.
All right, see you, Kenny.
Thank you, Judge.
Yes, sir. You're welcome.
Not sure where all these go. David Cruz, page 9, Your Honor.
Mr. Cruz. All right, this is cause number CR 20-0021-173, the state of Texas versus David Cruz, and set for status.
Yes, Your Honor, we just received some cases that were transferred from the county attorney's office. I spoke to Mr. Schmidt about it. If we could just reset it for another status.
Cases that they want you to consider as felonies?
Yes, Your Honor.
Or, okay, I didn't know for 1245s. All right, well then, Mr. Cruz, I'm going to reset your status to August the 12th at 1:30, okay? And so as soon as you receive that reset notice, you're free to go. We'll see you in August.
Okay, just give me a call. We'll be back on it. See you, David. Same page, Taylor Baker, Your Honor.
Taylor Baker. This is cause number CR 20-0651-173, the state of Texas versus Taylor Baker, set for status.
Judge, Mr. Cox forwarded me some information that Ms. Baker's former family law attorney sent to their office. That's not exculpatory this week. So I'd asked to reset that to review that and go over it with my client.
You all right with that, Ms. Baker? All right. Mr.
Fine,
Cox?
state judge.
All right, well, then I'm going to reset your status, Ms. Baker, to August the 12th at 1:30. So stay in touch with your bondsman and your attorney. We'll see you then.
All right, see you later.
Yes, sir.
Let's see, Judge. I think my only other one is Jimmy Marshall, is that correct?
Mr. Marshall, come on
Judge,
up.
that's gonna be a plea, I'm sorry.
Oh, no, it's going to be
I'm
a
gonna
plea.
get him signed up.
He's sorry.
Thank you.
Ms. Moore, everybody's sorry today. Yeah, you missed the morning doc. Kevin was sorry 3 or 4 times. Ms. Moore.
8.
It is page 8. Lisa Greer. Lisa Greer. She was at the crutches. Does she need to do anything other than trial docket says? Ma'am, you can just stay right there. You don't have to come all the way up in those crutches. Put your things like that. Well, I'm going to.
We don't have an agreement.
All right, this is CR 19-0741-173, the state of Texas versus Lisa Greer. Ms. Greer, can you hear me okay back there? All right, this is set for trial docket status. And for what announcement? Which day? Number 31 on. Oh, she's not in the top 10. All right, Ms. Greer, you're number 31 on the docket, and so it doesn't appear as though we're going to reach your case. I'm not going to give you a reset today. You will receive notice when your case hits the top 10. And so stay in touch with your lawyer and your bondsman. And however, before you go, I'm going to order you to take a drug test today. So you'll go with probation, take the test, and when you get done, come back in the courtroom and we'll go over the results together.
She's on some medication from her wreck, so I told her to bring that.
Yeah, just show probation, whatever you have there. That's it.
Mr. Jackson is my next client. I also think he's on page 8.
Stephen Jackson. These are cause numbers CR 19-0874-173 and CR 21-0031-173. All style or both style, the state of Texas versus Stephen Jackson, and both set. Now, I'm just going to call it status on each one. Where are we at?
Well, Your Honor, we are here and ready for a trial on CR 19-0874-173. But I guess the bigger case of the first degree felony this is the first status conference. And I'm seeing if we could get another date. Mr. Jackson is having a medical issue with a detached retina that he needs to attend to. And I would like for him to wait till after his surgery and make sure he's okay before we do anything.
Yeah, because he would. I mean, number 36, it'll be the same as Ms. Greer. Is that Mr. Jackson? What I'm going to do is I'm going to deem status is held on 0031. That way we can run the cases together. Is that what you want to do?
Yes.
And then you're number 36. And so I don't know whether the state, I don't even know the circumstance. So I don't know if you try them together, if it's possible to try them together or not. However, Mr. Jackson, you will not receive a reset notice. Is that correct? Even on the status case? Because he's being.
For the later case, we can just.
Yeah.
Could we do that? maybe
Yeah,
for
let's do that.
August?
So I will just reset them both for August 12th at 1:30.
Okay, yeah, I should be. Trying to get it done next week.
Is he free to go? Did
Yes,
he-
sir. Oh, no, he's got to take a drug test. I'm sorry. Mr. Jackson, you're also going to take a drug test today. You know the drill. Go to probation. When you're done, come back in the courtroom. We'll go over the results together.
I'm trying to still swap the sisters.
Yes, sir.
State of Texas versus Louisiana County.
Sir. Mr. Kennedy. This is cause number CR 18-0513-173, the state of Texas versus William Kennedy, and we are set for status. Where are we at?
Your Honor, we've made a 6-year offer in this case. Mr. Mayo is going to be getting me some information that previous offer has been made. That I'm going to look at and consider. So we're still talking about things.
Good.
in the future.
Y'all want another status?
Probably be best, Your Honor.
Okay. All right, well then, if it looks like we can work it out, but if it looks like we're not, I'd just rather put it on the trial.
Right. And if I go back to him and say, hey, here's what we have, this is the best they can do, then I'll let her know.
Sure.
And let the court know.
All right, well then I'm going to reset your status, Mr. Kennedy, to August the 12th at 1:30. And so make sure you abide by any conditions of bond, stay in touch with your attorney and your bondsman, and we'll see you in August.
Your Honor, we took second in Florida.
Did you?
Yeah, took second in Florida, then didn't do so well in Georgia.
Yeah, we're still on the grind. We're in Melissa actually today, but I couldn't make it.
Yeah.
And then we're in Houston next week for a perfect game, and then we have a scout day, and then we're done.
Yeah.
At least for this.
We go to Houston, tomorrow,
Oh, do you?
playing U of H and Rice.
I got you. Yeah, we were there about a month ago. I liked it. Not Rice was nice.
Yeah.
Yeah, good to see you. Good luck to you. Yes, sir.
Page 5, Daniel Price. He's on 6.
Come on up, Mr. Price. These are cause numbers CR 20-0343 and 0615-392, and then CR 21-0203, 0204, 0205 -392, and then all of these are styled the state of Texas versus Daniel Price. Set for status, all of them. Where are we at?
Judge, I think the last offer we got was 40, and he wishes to reject that offer.
And that would have taken care of everything.
I believe that's right, Judge. Judge, if we go ahead and put him on the trial docket, we're a good ways apart.
Okay, well then, and so is there any alleged enhancements?
He's 25 to life on 2 of the
25 to life
cases
on probably the Burgahabs
in the possession.
in possession. Okay. All right, Mr. Price, I presume you're innocent as you stand there. I don't presume you any other way, but you understand if you do go to trial and you're found guilty beyond a reasonable doubt, and if the state proves the 2 enhancement paragraphs 2, it'd be the minimum of 25 and a maximum of 99 or life. You understand? I understand. So the court notes that you've rejected the plea offer, and we will set these on a trial docket status date, and he is number,
Well, he's gonna be around 3 or 4, so
Okay.
we need to set him for announcement on August 9th.
announcement for August 9th, 9 o'clock for jury selection.
We got 2 dates, we have to figure that out.
Okay.
16th. and the 20th.
Let's just keep it for announcement on August the 6th at 9 a.m. And so as soon as you receive that reset notice, Mr. Price, you can have a seat.
They have a Keith Rucker. Page 7.
Keith Rucker. These are cause numbers CR 0656 and 0657-173, both style, the state of Texas versus Keith Rucker, and both set for status.
Judge, basically where we are, Mr. Rucker has a new possession and a failure to comply with registration requirement case from June the 8th or 9th or something like that. So we were going to ask the court to give us another status date and let us, he's not been indicted on those cases. I don't know what. The court want to reset that for 30 days or so out and see if we'll.
Have you all filed a motion to no bonding?
I don't believe so. no,
Or
sir.
they
I'm
increased
still
them?
waiting to get some information from the law
Okay.
enforcement.
Well, you'd have to be indicted before you could do that, but you could file a motion to increase his bond.
Yes, Your Honor.
All right.
We do, based on his charge, we would like him to be drug tested.
No, I'm going to.
Yes,
All right. All right. Well, then I will reset status and let y'all figure that out till August the 12th at 1:30. However, Mr. Rucker, I'm going to order you to take a drug test. You'll go with probation, take the test. When you get done, come back to the courtroom and we will go over the results together.
Zuniga,
Zuniga, David Zuniga. Cause number CR 20-0697-173, the state of Texas versus David Zuniga. And set for status. Is there a David Zuniga in the courtroom?
He said he had no right. I told him we needed to.
Okay. All right, is there a David Zuniga in the courtroom? I see no one. I hear no answer. He is not in the lobby. He has called the court and said he didn't have a ride. However, time is now 1:53. He was scheduled to appear at 1:30. The court will entertain a motion.
Take this for law enforcement.
Granted, a capious issue, he'll be held with no bond.
back on page 5, Your Honor, Jason Passons.
Jason Passons. Ooh, it's not bad. Our batting average staying very good. Our batting average staying very good. We've struck out a number of times.
All week.
It has been.
Have you noticed the numbers?
Yeah.
5 or 6 of them.
Cause numbers CR 21-0043 and 0044-173. Both styled the state of Texas versus Jason Passons. Is there a Jason Passons in the courtroom? I see no one. I hear no answer. There's not a Jason Passons appearing via Zoom. Time is now 1:54. Mr. Passons was due in court at 1:30. The court will entertain a motion. Granted, capious issue, he'll be held with no bond. And I'm here all day. If we, I did.
Okay, I think that's all I have. Have any excused?
Yes, sir.
Thank you.
See you. Mr. Schmidt. Mr. Marshall, come on up. We're ready for you now, sir. It's been long in weeks. People's not showing up. It's rampant. I think I have a solution. Drafting an order.
Send Ronnie after.
That's it.
Send Ronnie after.
Seems to be having a problem with the bonding company. It's not getting their people. All right, this is cause number CR 20-0027-173, the state of Texas versus Jimmy Paul Marshall. And this is set for status today. However, a plea has been presented to the court. Is the state ready?
We're ready, Ron.
And on behalf of Mr. Marshall.
Yes, Your Honor.
All right, sir, is your name Jimmy Paul Marshall?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for this third-degree felony offense of possession of a controlled substance?
Yes.
If I can get you to raise your right hand, sir. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Marshall, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Marshall, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Schmidt, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is. Mr. Marshall, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the court?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a third-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range of punishment?
Yes, sir.
However, it's my understanding that in exchange for your guilty plea, the state is willing to recommend to the court that you would plead guilty to a lesser included offense of that which is charged in the indictment, which is a state jail felony, which carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine of up to $10,000. Do you understand that punishment range?
Yes, sir.
And further, they're requesting the court in exchange for your guilty plea that although you'd plead guilty to a state jail felony, you would be punished as a misdemeanor, a Class A misdemeanor, which carries a punishment range of up to 1 year in the county jail and a fine of up to $4,000. Do you understand all those punishment ranges
Yes, sir.
in the plea bargain?
Your Honor, we're asking the court to defer a finding of guilt and place the defendant on probation for 2 years. He's got 2 days credit towards a potential sentence. There's $1,000 fine, attorney's fees, court costs, lab restitution, and all the standard terms. that you get.
Is that your understanding of the plea bargain, Mr. Marshall?
Yes, sir.
Is that your understanding, Mr. Schmidt?
It is, Judge.
Well, Mr. Marshall, a few minutes ago, you told me you could read and write the English language. I'm going to go over a couple documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document with Mr. Schmidt?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Schmidt?
Yes, sir.
And did you sign that second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with?
No, sir.
Well, if you read and went over these with Mr. Schmidt, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to waive your right to a jury trial and enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that lesser included offense of that which is charged in the indictment, that state jail felony offense of possession of a controlled substance punished under 1244A of our penal code? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
Judge, I have states 1 in offense report, states 2 is Michael Martin compliance, and states 3 is a lack report.
No objection.
Admitted.
State rests.
Judge, I don't have any evidence. I will tell the court if it's okay with the state. I mean, I think it's no secret based upon past court appearances. My client has a drug problem. And he is preparing to take a medical leave of absence from his federal job. He of course has insurance and try and get a good start to his probation by checking into a rehabilitation facility. I think you have that, and not a date scheduled. Is there a date?
Getting pre-authorized right now.
Being pre-authorized right now,
So
so
it's Monday.
perhaps Monday. I know it's not a condition of his probation, but we just like the court to know that, you know, allow that because the state wouldn't have to pay for it and he can get a jump start on getting
Absolutely.
clean.
If it's okay with probation, it's okay with me. And it's probably scary as heck to think about going in, and it's the right thing to do, right?
Yeah.
Yeah, I can imagine. And so, anything else?
No, sir.
All right, well then, Mr. Marshall, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will defer making any finding, places you on 2 years of community supervision for a Class A misdemeanor. You do have 2 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, and lab fee, and abide by all the regular and special terms and conditions of community supervision. And Mr. Marshall, have you ever been on probation?
Once. Yes, sir.
Did you successfully complete it?
Yes, sir.
You know what can happen to you if you don't complete this probation?
Yes, sir.
What can happen?
I'll go to jail for.
You can go to jail for up to a year. Here's what can happen. If you violate even one term or condition, a motion would be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and if at a hearing, the court found you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to a year in county jail. You understand?
Yes, sir.
All right, so good luck to you, sir.
And
seek
most
probation
importantly,
for
something you said is, I know what you meant, but place him on probation for a class A misdemeanor. He's actually being placed on probation for a state jail.
That's
felony.
right. That's right. I'm
And so
sorry.
if he would get a felony conviction, if he's been
It
with
would.
it, and so he understands how important that is for his federal employment.
Right, I meant for the term of a misdemeanor. But if you were to get revoked, you could be revoked and found guilty of a felony. I should have said that.
No,
Right. Well, good luck to you, sir. You need to see probation.
good luck to me.
And good luck in treatment.
My excuse.
Yes, sir.
Thank you.
Glad y'all got that one with you. Is that what he just said?
Yeah.
Okay. Mr. Scott,
Orville Jones, on paper 9, Your Honor.
Orville Jones.
Yeah, that's a plate.
Okay. Alrighty, this is cause number CR 21-0358-173, the state of Texas versus Orville Dean Jones. And this was set for a plea today, and a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Jones,
Ready, Your Honor.
sir, is your name Orville Dean Jones?
Yes, sir.
And are you the same person that was originally indicted in this third-degree felony offense of assault family violence?
Yes, sir.
And get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God. You can lower your hand. Mr. Jones, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, I do.
And Mr. Jones, have you ever been treated for any mental health or emotional issues? Now, you have to answer out loud because the court reporter has to take it down. Thank you. And do you understand what's going on in here today?
Yes, sir.
And Mr. Scott, do you believe your client is competent?
I do, Your Honor.
And the court finds he is. Mr. Jones, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a third-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range of punishment?
Yes, sir.
However, it's my understanding that you had this deal worked out with the state whereby you would plead guilty to a Class A misdemeanor, which is of assault family violence, a lesser included of that which is charged in the indictment. A Class A misdemeanor carries a punishment range of not more than 1 year in the county jail and a fine up to $4,000. Do you understand that, right?
Yes, sir.
In the plea bargain?
Yes, Your Honor. State agreed plea recommendation is to abandon paragraph A, proceed on the paragraph B, plead to a lesser included Class A misdemeanor assault family violence, 5 days in the county jail with 5 days of credit, attorney's fees and court costs.
They're not labeled as A and B, so they're not counts. They're,
That's correct.
okay. And so you're just proceeding on paragraph B.
That is correct, Your Honor.
Right? Is that your understanding, Mr. Jones, of the plea bargain?
Yes, sir.
And is that your understanding, Mr. Scott?
Yes, sir.
Well, Mr. Jones, a few minutes ago, you told me you could read and write the English language. I want to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Scott?
Yes, sir. I did.
And did you sign the front and the back?
Yes, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir. I
And
did.
did you sign that second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Scott?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? You want to do this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to paragraph B of that indictment, the lesser, I'm sorry, let me rephrase it. How do you plead to the lesser included offense of that which is charged in paragraph B, the assault family violence, a class A misdemeanor? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
Your Honor, state offer states Exhibit 1, the offense report states Exhibit 2, the discovery inventory report.
No objection, Your Honor.
Admitted.
And Your Honor, the complaining witness has been notified in this interview.
Okay.
State rests and closes.
Defendant rest, Your Honor.
All right, Mr. Jones, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense, the assault family violence as charged in paragraph B of the indictment. Court will follow the plea bargain, sentences you to 5 days in the Henderson County Jail with credit for 5 days. Notes that the complaining witness is on board with the plea bargain and orders you to pay your attorney fees and court costs. And Mr. Jones, before you go, have you had an opportunity to review the judgment in your case?
Yes, we will.
Yes, yes,
Is
sir.
your name, the charge, and the time credit correct?
Yes, sir.
All right, sir. You need to see Mr. Halbert before you leave. Good luck.
Thank you.
Sir.
And my next one is Lagunas. I have an interpreter on that one.
Okay, is it just a status? Or is
Yeah,
it-
it's a pretrial. I'm gonna ask for another one though.
Okay.
I got appointed to replace another attorney and
Sure.
I just got a ton of discovery a couple weeks ago.
Lagunas?
It's on page 10 and 11 and maybe even 12. This is John Krieger, my interpreter. Your Honor.
All right, sir. I'll swear the interpreter first. If you'll raise your right hand. You solemnly swear that you will translate from English to Spanish and Spanish to English to the best of your ability.
I do, Your Honor. And for the record, my name is John Kriegel, license number 545.
All right, thank you, sir.
Thank you.
All right, I'll call these cases then. These are cause number CR 20-0397 through 0401-173, all styled the state of Texas versus Arturo Lagunas, and all set for pretrial. Any pretrial from the state?
Yes, Judge, I have for each cause number our standard motion for discovery.
No objection, Your Honor.
Granted. And on behalf of Mr. Lagunas,
Your Honor, I filed a motion to suppress on July 7th. I would eventually like to get that set, but I still have more discovery to go over. And there's some statements that I got that are in Spanish and I need the help of my interpreter to go over those. So I need at least another month if the court could give me that for
Any
another
objection?
pretrial.
No, Judge.
and I will note that Mr. Scott was recently replaced as an attorney on this case. Isn't that correct?
That's right, Your Honor. I believe this is my first setting as his attorney.
Well, Mr. Kevin left. Well, month, I guess August the 12th. Why don't we just reset for August 12th? Y'all check that date.
I'm free.
Are you free, Mr. Combs?
I think I'll be here, Judge.
I think I'm gonna be here too. You gonna be here? Well, should be in school. I should be. When the creek don't rise.
That's, he hasn't said yet. That's good for us.
1:30.
1:30.
We're calling that another pretrial.
Just reset the
Yes.
free trial.
Now, I don't need to be ready for a contested hearing that day, correct?
No, I wouldn't want to do that. I'd rather just maybe we could schedule that on that day.
Sure. We'll do that another day. All right, then, Mr. Lagunas, I have reset pretrial at your attorney's request to August the 12th at 1:30. So we will see you on August 12th.
That's it.
Thank you.
Thank you, sir.
Thank you, Honor.
Appreciate it.
Yeah, be excused.
Yes, sir.
Thank you, Honor.
Your Honor, can we meet in the jury
Sure.
room? Okay, thank you. That's my last case, I believe. If I can be excused after
Yes,
that.
sir. Mr. Stevens,
Yes, sir. I think I start on page 12.
Roderick Benton,
Yes, sir. Whichever order you want to call them in, sir.
we go right down the line. Roderick Benton. All right, this is cause number CR 20-0689-173, the state of Texas versus Roderick Benton, set for status.
We are, Your Honor. I'm going to ask for another status setting. I've gotten 2 competing offers of punishment on Mr. Benton's case. And I need to sit down and visit with the prosecutor again and my client, Your Honor.
Remember the offers made, you make it recent?
Your Honor, there was another case in another county, so
Mr. Benton, you're the one on bond. You all right with that?
We're going to basically reset your case.
Oh, yeah. Okay, so.
All right, well, then we'll reset your status to August the 12th at 1:30. So as soon as you receive that reset notice, you're free to go. Just if you got any conditions of bond, make sure you bond. Thank you, sir.
Thank you, Judge.
Teora Jaeger or Jager? I know I ask you every time, is it Jaeger or Jager? Jager. Do we have a plea?
It is, Your Honor.
Okay. This is cause number CR 20-0488 -173, the state of Texas versus Teora Nicole Jager. And this is set for a plea today, and a plea has been presented to the court. Is the state ready?
We are, Your Honor.
And on behalf of Ms. Jager,
Ready, Your Honor.
ma'am, is your name Teora Nicole Jager?
it's Tara.
Tora.
Yes, sir.
And Ms. Jager, are you the same person that was originally indicted by a Henderson County grand jury in this second-degree felony offense of possession of a controlled substance?
Yes, sir.
I can get you to raise your right hand, please, the best you can. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Ms. Jager, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Ms. Jager, have you ever been treated for any mental health or emotional issues? Do you understand what's going on here?
Yes, sir.
Mr. Stevens, do you believe your client is competent?
Yes, sir.
And the court finds that she is. Ms. Jager, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
Yes, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a second-degree felony, which carries a punishment range of not less than 2 years or more than 10 years, or more than 20 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range of punishment?
Yes, sir.
In the plea bargain?
Your Honor, it's 5 years confinement, TDC credits for 142 days served, plus attorney's fees, court costs, and live restitution.
Is that your understanding of the plea bargain, Ms. Jager?
Yes, sir.
Is that your understanding, Mr. Stevens?
Yes, Your Honor.
Ms. Jager, a few minutes ago, you told me you could read and write the English language. I'm going to show you 2 documents. First is the agreed plea recommendation. Did you read and go over both the front and the back of that document with Mr. Stevens?
Yes, sir.
And did you sign both the front and the back?
Yes, sir.
Do you have any questions about it? The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign the second
Yes,
page?
sir.
Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with Mr. Stevens? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? Do you want to do this plea bargain? Then I'll ask you, ma'am, how do you plead to that second-degree felony offense of possession of a controlled substance? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason? I'll hear the evidence.
Judge, I have stage 1 an offense report. Stage 2 is Michael Moore compliance, and stage 3 is a lab report.
No objections.
Admitted.
State rests.
Defense will rest and close. Ask the court to follow a plea bargain.
All right, Ms. Jaeger, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that second-degree felony offense as charged in the indictment. The court will follow the plea bargain, sentences you to 5 years in the Texas Department of Criminal Justice with credit for 142 days and orders you to pay your attorney's fees, court costs, and lab fee. And Ms. Jaeger, before you go, have you had an opportunity to review the judgment in your case? Was your name, the charge, and the time credit correct? All right, ma'am, now that you've been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult an attorney. You're now remanded back to the custody of the sheriff for transport to TDC to serve out your sentence. Good luck to you, ma'am. You need to see the bailiff before you sit down. Ulysses Roberts.
Yes, sir. I'm ready.
Ulysses Roberts. All right, this is cause number CR 19-0313-173, the state of Texas versus Ulysses Roberts, and that is set for status. Actually, there's another one too.
Yes.
Well, let's handle the status and then we'll arraign him. Where are we at on that? We're just gonna let it just, does he even have an offer on that one?
On the new one, Judge?
No, on the older one. I want to see where we're at. In other words, would that offer wrap all these up? Okay. All right, well then, let's call this new case CR 21-0552-173. Styled again, the state of Texas versus Ulysses Roberts. And that is set for arraignment. Mr. Stevens.
Yes, Your Honor, may it please the court. Mr. Roberts would advise the court his name spelled correctly. He understands the nature and consequences of the charges. We will waive reading of the indictment, enter a plea of not guilty to the charge. In addition, enter a plea of not true to the enhancement progress.
All right, Mr. Roberts, the court notes your plea of not guilty as well as not true to any enhancement paragraphs. Your two next court dates on this case are September the 8th for discovery status at 1:30. And then again on October the 13th for a pretrial, also at 1:30. And then on the status case, I'm just going to reset that status until this one catches up to September 8th at 1:30. And as soon as you receive that reset notice, Mr. Roberts, you can have a seat, sir.
Oh, 9-8. 10-13. Um, 1:30, I think. 1:30.
Yes, sir.
I got distracted, sorry, Judge.
Okay. That's it for me, Judge. My excuse.
Yes, sir.
Thank you, sir.
Ms. Fallhaber.
I've got Shannon Brown on page 1, please.
Shannon Brown. What are we doing, just status?
We actually reached a plea agreement.
Okay. All right, this is cause number CR 20-0605-173, the state of Texas versus Shannon Brown. That is set for status today. However, a plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Ms. Brown,
Ready, Your Honor.
and is your name Anna Brown?
Yes.
And are you the same person who was originally indicted in this case for the state jail felony offense of abandoning or endangering a child by criminal negligence?
Yes, sir.
If I can get you to raise your right hand the best you can, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Lower your hand. Ms. Brown, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand it? And Ms. Brown, have you ever been treated for any mental health or emotional issues?
Me too.
Do you understand what's going on in here today? And Ms. Fallhaber, do you believe your client is competent?
I do, Your Honor.
And the court finds she is competent. Ms. Brown, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No thanks.
But do you understand the charge? Well, as indicted, that charge is a state jail felony, which carries a punishment range of not less than 180 days for more than 2 years in a state jail felony facility and a fine of up to $10,000. Do you understand the range of punishment in the plea bargain?
Yes, Your Honor. It is 2 years probated for 5 years on probation. Judge, I just noticed a typo because she has time credit of 32 days, and that is through today, which is 7/15 of 21.
I see the 415. I got you. Change it.
It's a $500 fine, $875 in attorney fees, $290 in court costs. Her conditions of probation are AA or NA meetings, $50 to Crime Stoppers, a year analysis testing as directed by your probation officer. You have to obtain a GED within 24 months or show proof of your high school education, attend life skills, 200 hours of community service at 10 hours a month, comply with all the child protection service requirements, attend drug offenders program, complete the substance abuse evaluation and follow the recommended treatment, attend a parenting class, and you have to do 75 days in the county jail as a condition of that probation, but you get 32 days credit towards that. We are also agreeing to consider and dismiss the new abandoning and endangering a child from the 5/12 of 21, and there should be 2 counts on that one. And also a misdemeanor of resisting arrest, search, and transport from 6/24 of 21.
Just so it's clear for the record, Your Honor, this plea is on count 1 and 2 of the 2-count indictment.
We have one of these.
At the top, it says counts 1 and 2.
Normally we'll do a separate plea packet for each one. Okay. I do see counts 1 and 2, you're right. I mean, in the old days, we used to do it like that, but it seems like in the past year or so, they've been doing it with 2 separate ones, so that's fine. I understand now. All right, and so let me back up a little bit. Ms. Brown, when I went over the range of punishment, apparently you have 2 counts. So for count 1, that it's the same range of punishment as for count 2 that I went over earlier. Do you understand the range of punishment in both? Now, is that your understanding of the plea bargain, that you would plead guilty to both counts 1 and 2? All right, is that your understanding? Ms.
It is,
Fallhaber?
Your Honor.
Well, Ms. Brown, a few minutes ago, you told me you could read and write the English language. I'm going to show you 2 documents here. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that with Ms. Fallhaber? And did you sign the front and the back? Do you have any questions about it? The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Now, this document applies to both counts 1 and 2. Did you read and go over that with Ms. Fallhaber?
Yes.
And did you sign that second page there?
Yes.
Do you have any questions about it?
Yes, sir.
Do you have any questions about any of the documents that you read and went over with Ms. Fallhaber? Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury in each of these counts. Do you understand this? Do you want a jury trial? Do you want to enter into these plea bargains? Then I'll ask you, ma'am, how do you plead to that state jail felony offense of abandoning and endangering a child by criminal negligence in count 1? Are you guilty or not guilty? Also, how do you plead to that state jail felony offense of abandoning or endangering a child by criminal negligence in count 2? Are you guilty or not guilty?
Guilty.
And are you pleading guilty to each of these counts because you are guilty and for no other reason?
Yes.
I'll hear the evidence.
State offer states 1, which is a copy of the police report, and states 2, which is a copy of the inventory report.
No objection.
Admitted.
Say rest in peace.
Rest in peace.
All right, Ms. Brown, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense in count 1. Based upon your guilty plea and the evidence, the state, or in count two, the court has the evidence to find you guilty and does find you guilty of count two. The court will follow the plea bargain. The court, in punishing you, is considering these abandoning, endangering a child case, 2 counts from 2021, and the resisting arrest or transport from June of 2021. The court then sentences you in each count to 2 years in state jail. However, the court will probate that, places you on community supervision for 5 years. You do have 32 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, and court costs, and to abide by all the regular and special terms and conditions of community supervision, including that 75 days in the county jail as a condition. And Ms. Brown, now that you have been finally convicted of these 2 felony offenses, you are now, under Texas law, ineligible to possess a firearm or ammunition. If you have any questions, you need to see an attorney. Good luck to you, ma'am. You need to see Mr. Halbert to your right.
Thank you, Judge. That's all I have. Maybe.
Yes, ma'am. Thank you.
May I as well?
Yes, ma'am. Thank you.
Can I see her on?
Yes. I don't think so. They changed it one time when I. Mr. Hunt. Mr. Leverton. It's a plea.
It is a plea, Your Honor.
Okay. You see it, Rick. They've been going all week.
It has been a busy week.
Yes. All right. Ready? Let me sign them and then I'll call you. You ready? All right, this is cause number CR 21-0246-392. The state of Texas versus Jimmy Curtis Leverton. Is it Lever or Lever? Leverton. And set for a plea today, and the plea has been presented to the court. Is the state ready?
We are, Your Honor.
And on behalf of Mr. Leverton.
Mr. Leverton's ready, Your Honor.
All right, sir, is your name Jimmy Curtis Leverton?
Yes, Your Honor.
And are you the same person that was originally indicted in this case on the 3rd-degree felony offense of possession of a controlled substance?
Yes, Your Honor.
I get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
You can lower your hand. Mr. Leverton, can you read and write the English language?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand?
Yes, Your Honor.
And Mr. Leverton, have you ever been treated for any mental health or emotional issues?
No, Your Honor.
Do you understand what's going on here today?
Yes, Your Honor.
And Mr. Hunt, you believe your client's competent?
I do, Your Honor.
And the court finds that he is. Mr. Leverton, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the court?
No, Your Honor.
But do you understand the charge?
Yes, Your Honor.
Well, as indicted, that charge originally is a 3rd-degree felony, which carries a punishment range of not less than 2 years and more than 10 years in the Texas Department of Criminal Justice, and a fine of up to $10,000. Do you understand that range?
Yes, Your Honor.
However, it's my understanding that you have this deal worked out with the state whereby they would recommend that the court convict you of a state jail felony, a lesser included offense of the one charge in the indictment. And that carries a punishment range of not less than 180 days, no more than 2 years in a state jail felony facility, and a fine of up to $10,000. Do you understand that range?
Yes, Your Honor.
And further, under 1244A of our penal code, they would recommend that you be punished as a misdemeanor, a Class A misdemeanor, which carries a punishment range of up to 1 year in the county jail and a fine of up to $4,000. Do you understand all those punishment ranges?
Yes, Your Honor.
In the plea bargain in the case?
Your Honor, it's 96 days confinement, I'm sorry, 95 days confinement in Henderson County Jail with credit for 96 days served, plus attorney's fees, court costs, and life restitution.
Is that your understanding of the plea bargain, Mr. Leverton?
Yes, Your Honor.
Is that your understanding, Mr. Hunt?
It is, Your Honor.
Well, Mr. Leverton, a few minutes ago, you told me you could read and write the English language. I'm going to go over two documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Hunt?
Yes, Your Honor.
And did you sign the front and the back?
Yes, Your Honor.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, Your Honor.
And did you sign the second page?
Yes, Your Honor.
Do you have any questions about that document?
No, Your Honor.
Do you have any questions about any of the documents you read and went over with Mr. Hunt?
No, Your Honor.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, Your Honor.
Do you want to do this plea bargain?
Yes, Your Honor.
Then I'll ask you, sir, how do you plead to the lesser included offense of that which is charged in the indictment, the state jail felony possession of a controlled substance? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, Your Honor.
I hear the evidence.
Judge, I have states 1 offense report, states 2 is Michael Morton compliance, and states 3 is a lab report.
No objection.
Admitted.
State rests.
Defense rests.
All right, then, Mr. Leverton, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony lesser included offense. Excuse me, the court will follow the plea bargain, punishes you under 1240, or sorry, sentences you under 1244A of our penal code. The court is considering the unindicted bail jumping case and punishing you, sentences you to 95 days in the Henderson County Jail with credit for 96 days in order to pay your attorney's fees, court costs, and lab fees. And Mr. Leverton, before you go, have you had an opportunity to review the judgment in your case?
Yes, Your Honor.
Was your name, the charge, and the time credit correct?
Yes, Your Honor.
All right, sir, now that you've been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions, consult an attorney. And good luck to you, sir. You need to see Mr. Halbert before you leave.
Thank you, Your Honor. May we
Yes,
be
sir.
excused?
Sir, appreciate it.
Thank you, Judge.
Okay,
Thank you, sir.
Ms. Moore.
Test results for Mr. Jackson. He is negative.
Mr. Jackson, you passed your test. You're free to go. Also, Mr. Rucker, pass your test. You're free to go.
Ms. Greer is not able to go due to the medication she's on. So
Well,
the
she'll
probation
eventually
office
go.
just informed me of that.
Let's see this, he wants to call you.
Well,
You have more
I
cases?
do have Mr. Dick. I think we're ready for something.
Come on up, sir. All right, this is, or sorry, these are files numbers CR 21-0064 and CR 19-0807-173, both styled the state of Texas versus Scott Dick. And both will, 807 set for trial docket status, the other for status.
Your Honor, Mr. Dick and I have been negotiating with the state. We got close to an agreement. We don't have an agreement. Mr. Dick's awaiting some test results from I think it's a CAT scan that he got that he's supposed to get tomorrow. He's questioning his competency.
He's questioning it or your question?
No, I'm not questioning that. Mr. Dick has expressed that he's starting to suffer from dementia. And while I've had an ability to communicate and discuss this case with him. I told him I think he's competent, but if he does not think he's confident, that I would inform the court. But he's really wanting to see what his test results say that he's supposed to get tomorrow.
Does he have an offer?
Yes, Judge.
And it is
3 years,
3 years. How much time's he got?
a lot.
I'll have a lot of count. I'm just trying to figure out how much time.
Probably has he's been in jail this time since November. of
He knows how
20
many days he's got. Mr. Dick, how many days credit do you have?
And then
okay.
prior to that, he probably had 4 or 5 months. So he's told me about over a year credit.
And these are,
It's enhanced to habitual offender.
Yes, as indicted, there's 25 to life.
so let me get this straight. So Mr. Dick's offer is 3 years TDC.
That's the state's offer. Yes.
Well, the offer to
I'm
him
sorry.
is 3 years TDC. But if Mr. Dick were to be convicted on each of these cases, and you could try him twice, could you not?
Yes, sir.
And these can be stacked, could they not?
Yes, sir.
Because of the types of cases. So Mr. Dick, I just want to explain to you that, and again, I presume you innocent. I don't presume you any other way, but I'm just going to tell you the reality of the situation. If you went to trial on each of these cases and you were to lose on one or both of them, if the state were to prove their case to a jury or the court beyond a reasonable doubt, when you went to punishment, if they prove these 2 enhancement paragraphs true, the minimum by law that a court or a jury could give you is 25, even if they wanted to give you less. You understand that? And they wouldn't even know you had those 2 enhancements until they went back there to deliberate on punishment. And so they wouldn't have a choice, even if they didn't want to. And further, if you were to be found guilty in both cases, like say you had 2 different trials, then the court could stack them on top of each other. In other words, they wouldn't be served consecutively. I mean, concurrently, they'd be served consecutively. In other words, if you got the minimum, you do the 25, and then when it stopped, you do the others. And there's a 3-year offer on the table. Do you understand that?
I was just wanted just to delay till I get my results back from my CAT scans.
Fair enough.
I mean, that's all I'm asking.
Okay, well, it sounds like you understood everything I just explained, and that's pretty complicated. I find you're competent. All right, and so.
Yeah, I'm confident.
Okay, well, what's the CAT scan for? Brain?
Well, he's expressed to me that he's beginning stages of dementia, and I think that's, is that what
I get ready to turn 51. I think I am too sometimes. The court reporter or the court coordinator was earlier today too. So
I'm 65.
I don't mean to make light of it, but I understand. All right, well, Mr. Dick, I'm going to reset your cases to August the 12th at 1:30. Is that offer open?
I'll leave it open, Judge.
Okay, you're gonna leave it open until August 12th at 1:30? All right, Mr. Dick, that offer is open until August the 12th at 1:30.
Yes, sir.
Thank you.
All right. We'll see, we'll wait it out and see. I don't want to be here all day. Mr. Head. Michael Welsh. All right, this is cause number CR 18-0775-3. Just did why do I have a -3 case? I probably ask that every time we're in here.
I think this one was, it was originally actually in the 173rd and then it was transferred over.
How did I get it?
I think potentially because of the code written on it.
Maybe. but-
Her case was in this court. I'm not really sure.
Okay, anyway, the state of Texas versus Michael Wells set for trial docket status.
There's not an offer on the table at this time. I did receive a list of providers from the adoptive mother of the victim yesterday.
Okay.
And I think the state needs to go ahead and subpoena records from those providers. I expressed that to Mr. Head. I also filed a motion with the court earlier today asking for a hearing on the victim being able to testify by closed circuit television.
I know there's a provision in the code that allows it. I've just never done it as a judge. I think I've done it as a prosecutor. What does the state have to prove? Right, it has to prove something that it doesn't violate his Sixth Amendment right to confront.
That's correct, Your Honor. There's case law on the issue and we present witnesses and evidence. At the time of the hearing, if the court would allow that.
Okay, and how long do you think it'll take you to get these records?
They're out of state.
Is it a governmental agency? No, you'll probably get them pretty quick. Then.
I'll call them and see. I think at least 30 days.
I'm just trying to figure out when we want. I think an August setting may be a little too soon. Well, how about that November or that September? Well, I would like to have a chance for them to get the records and then rather have a hearing and we have the records and then have another one. I'd rather just do them both at once. Make sure that everybody has the records before we even have the hearing, because Mr. Head might want to know what's in those records before he has that hearing. It might affect the outcome of the hearing.
I understand. I agree, Your Honor.
Yes, sir.
So how about we set this for hearing? What if we set it in October? That gives plenty of time for the records to come in. Yeah. Mandatory governmental education. October 5th, 9 o'clock.
And that is on the motion that. the
Right,
state
that's on the
has.
motion, and we'll just call it, well, let's set it for a contested hearing. And how long do you think you'll need? 20, 30 minutes?
Say at least an hour, Your Honor.
That means it'll take all day. All right, so, or at least a
We'll have
half a day.
witnesses.
Yeah, well, let's mark off a half a day for it. Okay. All right, so we'll set it then. What day was it?
October 5th.
10:05, 9 a.m.
Mr. Head will already be here.
Mr. Head, you'll already be here.
And I'm sorry, just for clarification, is that also set for trial docket status that day or?
Let's just set it for status. If, if we're getting brand new discovery in, it's kind of unfair to the defendant to keep there. So I'll back it up to status, have the hearing and just see where we're at.
Thank you, Your Honor.
All right, Mr. Welsh, we'll see you October 5th at 9 a.m. Just remember any conditions of bond you may be in. Thank you, sir.
Chairman. And then, Your Honor, I think we should be ready for a plea on Cameron Elder.
I thought Cameron Elder, I saw something where somebody sued the state bar in federal court. How did that go?
What I read, the Fifth Circuit held that a mandatory bar is unconstitutional under the
Because
First
of the
Amendment.
political activities. So do we have to do anything, pay bar dues right now?
I think it's all, I mean, I'm sure they're probably gonna file a motion for rehearing or something, and so I
Probably gotta
think.
pay my bar dues to be safe. It got me thinking when I CLE stuff. All right, this is cause number CR 20-0371-173, the state of Texas versus Cameron Dane Elder. This is set for a plea today, and that plea has been presented to the court. Is the state ready?
We are, Your Honor.
And on behalf of Mr. Elder,
Yes, sir, Your Honor, we're ready.
sir, is your name Cameron Dane Elder?
Yes, sir.
Yes, I know. And are you the same person that was originally indicted by Henderson County Grand Jury for this third-degree felony offense of driving while intoxicated?
Yes, sir.
And get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. Okay, you can lower your hand. Mr. Elder, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Elder, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on with you?
Yes, sir.
And Mr. Head, do you believe your client is competent?
I do, Your Honor.
The court finds that he is. Mr. Elder, I know that we've already arraigned you in this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge, actually, it's a state jail felony. As indicted, is that true? Can I say indictment?
Yes, sir, Your Honor. I think it would be.
Okay.
It's no enhancements, just with a child passing.
Oh, I didn't see child. I see it right there. I didn't see it on the, because the judgment says BAC
Yes,
or
sir.
equal to B. Okay. Right. And so, Mr. Elder, the charge is a state jail felony, which carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine of up to $10,000. Do you understand that range of punishment?
Yes, sir.
Right in the plea bargain?
Your Honor, it's 1 day confinement in Henderson County Jail, credit for a day served with a $2,500 fine, court costs, lab restitution fee, and we're asking the court to consider a cause number 2020-0437 CCL2.
Can I ask why 1 day?
I'll let Mr. Head explain that.
Okay, well, I was going to ask, on most of these DWIs, at least in my experience, that there a minimum, like, isn't there some that you have a minimum of 3 days? Or am I thinking of misdemeanor?
I thought that's a second.
Your Honor, I think, I believe it is on a second, there's a minimum 3 days.
Okay.
I think if there's, that's my recollection. I'm not certain.
We'll make sure it's not illegal. I mean, no one, he's not going to complain, but well, I wouldn't go volunteering just yet. Well, I would too, if that would make or break this deal.
Yeah. Judge, I don't think if it turns out to be a less than the minimum punishment, then he can in any way benefit from it
Right.
being outside of the range. So,
And the state made the deal, so
We extended PTI offer, Judge, and he opted instead because of a work schedule to just
Understand.
pay a big fine and get it over with, take the conviction.
so is this one of those cases where there's some risk involved for the state?
I don't believe so.
Okay, I'll let Mr. Head explain this. All right, then, Mr. Elder, is that your understanding of the plea bargain?
Yes, sir.
And Mr. Head, is that your understanding?
it is, Your Honor.
Right. And Mr. Elder, a few minutes ago, then I asked if you could read and write the English language. You told me you could. Is that correct? I'm holding in my hand 2 documents, the first of which is the agreed plea recommendation. Did you read it and go over both front and back, Mr. Head?
Yes.
Did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
Yes, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that?
Yes, sir.
Did you sign the second page? Do you have any questions about it? Do you have any questions about any of the documents you read, excuse me, and went over with Mr. Head?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? You want to waive that right and enter into this plea bargain with the state?
Yes, sir.
And I'll ask you, sir, how do you plead to the lesser included offense of driving while intoxicated, a Class A misdemeanor? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
I'll hear the evidence.
Judge, I have states 1 in offense report, states 2 is Michael Morton compliance, and states 3 is a supplement.
No objection, Your Honor. I previously reviewed them.
Admitted.
State rests.
Mr. Head?
Your Honor, just in regard to the offer, Mr. Elder is working 14-hour days right now, and we had a PTI offer extended, but he hasn't even been able to get in to meet with me because other than just on court days. And we talked about what all the PTI would require or any sort of probation for that matter. And because of his work schedule, we felt like it was better just to try to pay a higher fine. In regard to the case itself, also, he had actually arranged a defensive driver or a designated driver on the date in question. He went out on a boat with some friends. When he got back to shore, the designated driver was intoxicated. That's how he wound up getting stuck
So
driving.
you were the less of the two drunk, pretty much.
And so I explained to him that's not a legal defense, but it's certainly some mitigating information. for the
Jury might
court.
consider it. Okay. All right, anything else then?
No, sir. Your
Where,
Honor.
where does he work at?
I work for myself and different mostly like friends of mine with their businesses whenever I'm on my free time.
What do you do?
Will build houses, do paint and stamp repair on cars.
Okay, I got you. All right, well, I'm glad that you work because too many people don't. All right, well then, Mr. Elder, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that Class A driving while intoxicated. The court, in punishing you, considers this filed unlawful carrying of a weapon. The court will follow the plea bargain, sentence you to 1 day in Henderson County Jail with credit for 1 day, and orders you to pay your fine and court cost as well as your lab fee. And before you go, Mr. Elder, if you get an opportunity to review the judgment of conviction in your case. Is your name, the charge, and the time credit correct? All right, sir. Good luck to you. You need to see Mr. Albert before you leave to your right.
That's all I had. Your
Yes, sir.
Honor.
Appreciate it.
Thank you.
I'm not sure if Kevin filled you in or not, but
Yes, he did.
so we had a trial week that just opened up.
He showed me the photograph in the obituary, so I recognized him from his booking photo.
Yeah.
Booking photo. That might have been the only picture they had.
It's probably the best picture they had.
Could be.
I saw Nancy at the gym at lunch and I showed her that. She said that she thought that Decent looked like Judge Torrance.
It's a murder we won't have to try. Unfortunately, though, the victim's family don't get their day of court and justice. That's the bad part of it. Oh, well. All right, anything else ready? Okay, I'm gonna go through the docket. And so for those folks that have not had their cases heard, if you hear your name, just let me know that you're here. Justin Edis. Okay. David Hutchins. Okay, your attorney's back there. Sam Osborne. Gotcha. Mr. Osborne, you're set for a plea today. Have you gone over paperwork? Okay. Lamonte Rodriguez. Got you, sir. We've been working harder than I thought. That's it, pretty much. It's just Mr. Harrington, right? Oh, I didn't see that. I see Brad's around here somewhere. Willie Davis. Okay, and Jalen Rockmore. Gotcha. All right, we're gonna go ahead and take a recess, a much needed one, actually. It's almost 3. And we'll take one to at least 3:15. And so if 4 until something's ready. At least 3:15 until something.
Excuse me. Close your office.
But you still have everybody start letting. Something already. On the right hand side. No, I'm just checking. Where you got that?
Just one.
That's just part of it. Now, the baby is 29 years old. So.
Yeah.
Oh, Jeffrey watched it.
Hey, thank you, Joel.
Is this my copy or is this?
costs.
All right. Please be seated. Thank you. Miss Greer can go. She can go. Yes, ma'am, thank you. All righty, let's see, continuing on with the announcements on the 1:30 docket, Mr. Stevens.
Your last page, Willie Davis.
Mr. Davis, come on up. Ooh, it's cold. Ain't needed. And my saltwater generator, or my chlorine generator stopped working with all the rain.
Yeah.
I had a bunch of salt, man.
It blew
Jinxed
through
myself.
pretty hard last night at our house.
All righty, this is cause number CR 20-0674-173, the state of Texas versus Willie Davis. This was set for status today. However, a plea has been presented to the court. Is the state ready?
Ready, Your Honor.
And on behalf of Mr. Davis?
We're ready.
All right, sir, is your name Willie Earl Davis?
Yes.
And are you the same person that was originally indicted in this case for the first-degree felony offense of arson? And get you to raise your right hand the best you can, sir. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
You can lower your hand. Mr. Davis, can you read and write the English language? Are you a U.S. citizen?
Yes.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? And Mr. Davis, have you ever been treated for any mental health or emotional issues?
Yes.
All right, and what would those be? Were you diagnosed with anything?
No.
Okay. Did you ever get put on any medication?
No, sir.
All right, well then, do you understand what's going on in here today? And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
The court finds that he is competent. Mr. Davis, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No.
But do you understand what it is? I'm sorry, I'm getting off ahead of myself. And so you understand what you're charged with?
Yes, sir.
Well, that charge as indicted is a first-degree felony, which carries a punishment range of not less than 5 years or more than 99 years or life in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand the range of punishment?
Yes.
However, the way this is indicted, the state has alleged 2 enhancement paragraphs. So if you were to go to trial and a jury or a court were to find you guilty beyond a reasonable doubt, and at punishment, the state proved these 2 enhancement paragraphs true, then your range of punishment will be not less than 25 years, no more than 99 years or life in the Texas Department of Criminal Justice in the same fine. Do you understand that?
Yes, sir.
In the plea bargain?
Your Honor, it's 5 years confinement in TBC, credit for 278 days served, plus attorney's fees and court costs.
Is that your understanding of the plea bargain, Mr. Davis?
Yes, sir.
Is that your understanding, Mr. Stevens?
It is, Your Honor.
Well, Mr. Davis, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Stevens?
Yes, sir.
And did you sign them?
Yes, sir.
Any questions about it?
No, sir.
The next document I'm referring you to or showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both those documents, Mr. Stevens? And did you sign the second one?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Stevens? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
Do you want to do this plea bargain?
Yes.
Then I'll ask you, sir, how do you plead to paragraph A of that indictment, that first-degree felony offense of arson? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes.
I'll hear the evidence.
Your Honor, I have states 1 an offense report and states 2 is Michael Morton compliance.
No objection.
Admitted is the pleading witness on board?
Yes, Judge, I spoke with her personally on June 11th. She just requested pen time.
Okay.
So, and I relayed that to Mr. Stevens.
Okay. Anything else?
No, Your Honor.
If I may call my client, Your Honor,
Yes, sir.
please state your name.
Whatever, Davis.
And we've talked about this case extensively, is that correct?
Right.
And I've told you that I've seen some issues with the case, and that if we had a trial, that there's a chance that under the letter of the law, the jury may not find that this in fact is an arson. We've talked about those factors, is that correct? And however, you also understand that if we had a trial and we lost, that the minimum would be 25 years.
Yes.
And you're currently on parole and have 9 years left on another sentence, is that correct? And taking all of those factors into consideration, is it your decision that you want to go ahead and waive that right to trial and go ahead and accept the offer that the state's made? Okay, and you're doing that on your own free will, is that correct? I haven't forced you to do that or try to threaten you into taking it, is that correct? And just given the fact that you never know what a jury could do, and the fact that you're looking at 25 to life, did those factors kind of play into you want to go ahead and accepting this offer?
Yes.
And are you satisfied with my representation?
Yes, sir.
I'll pass this.
No
Cross.
questions, Judge.
Anything else?
No, Your Honor.
Rest
We
in
rest and
close.
close.
All right, then, Mr. Davis, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of paragraph A of that indictment, that felony arson. The court will follow the plea bargain, grants the state's motion to abandon the enhancement paragraph, sentences you to 5 years in the Texas Department of Criminal Justice. You do have 278 days credit as of today and orders you to pay your attorney's fees and court costs. And Mr. Davis, before you go, have you had an opportunity to review the judgment in your case? Was your name, the charge, and the time credit correct? All right, sir, you're now remanded back to the custody of the sheriff for transport to TDC to serve out your sentence. Good luck to you. On these that are already, I'm not gonna read that stupid firearm thing again because we're already filming. Yes, sir.
We're ready, Mr. Rockmore.
Okay, what are we doing? The status?
Status, yeah, place on trial docket.
All right, Mr. Rockmore, come on up, sir. All right, this is cause number CR 21-0035-173, the state of Texas versus Jalen Rockmore, and set for status. Where are we at?
Your Honor, the state has made a pen time offer. I believe it was 15 years. My client's rejected that, asked to place it on the trial docket.
All right, and assault with a deadly weapon, first, second. Is there any enhancements?
No enhancements. He has no prior felony history. So
All right, then, Mr. Rockmore, court notes that you have declined the 15-year offer, rejected it, and we will place this case on the trial docket. How long you been in jail?
9 months.
So, yeah,
He's gonna be close, so I just need to see.
okay. I'm not going to give you a reset notice yet. We're going to see where you shake out the next couple of weeks. And so you're just below the top 10, I would assume. Okay. And so as soon as we get that figured out, we'll get a reset notice sent your way into your attorney. Thank you, sir.
Thank you.
Have a seat.
then that'll conclude my business. May I be excused? Thank you, Judge.
Yes, sir. Thank you for Oscar, please.
You can imagine.
Can you do it alone? Is he in jail? I was trying to say, look, man, no. I mean, if they want to conference me tomorrow, I'm available except between 11 and 1. All right, sorry. All right, this is cause number CR 20-0634-173, State of Texas versus Sam Osborne. And this was set for a plea today, and that plea has been presented to the court. Is the state ready? And on behalf of Mr. Osborne?
Ready.
All right, sir, is your name Sam Leonard Osborne? Yes, sir. And are you the same person that was originally indicted in this case on this third-degree felony offense of possession of a controlled substance? I can get you to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give now on trial to be the truth, the whole truth, and nothing but the truth, so help you God? So you can lower your hand. Mr. Osborne, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? And Mr. Osborne, have you ever been treated for any mental health or emotional issues? Do you understand what's going on? And Mr. Harrington, do you believe your client is competent?
Yes, sir.
The court finds that he is. Mr. Osborne, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the court? But do you understand the charge? Well, the original charge or the underlying charge is a third-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. You understand that range of punishment? However, it's my understanding that there's an enhancement paragraph. So if you were to go to trial and were to be convicted beyond a reasonable doubt and then went to punishment, if the state proved that this enhancement paragraph were true, that range of punishment would be that of a second-degree felony, not less than 2, no more than 20, and up to a $10,000 fine. You understand that, right? In the plea bargain?
Your Honor, it's 3 years confinement TDC, credit for 5 days served, plus attorney's fees and court costs and life restitution.
Is that your understanding of the plea bargain, Mr. Osborne? Is that your understanding, Mr. Harrington?
It is.
Well, Mr. Osborne, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. First is the agreed plea recommendation. Did you read and go over both the front and back of that document with Mr. Harrington?
Yes, sir.
And did you sign the front and the back? Do you have any questions about it? The next document I'm going to refer you to, I had the wrong one. Is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign that second page? Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Harrington?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to waive your right to a jury trial and enter into this plea bargain? And I'll ask you, sir, how do you plead to that 3rd-degree felony offense of possession of a controlled substance? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
Judge, I have 3 exhibits. States 1 is the offense report, 2 is Michael Morton compliance, and 3 is the lab report.
Objection. Admitted.
State rests.
Rest and close.
All right, Mr. Osborne, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that 3rd-degree felony offense of possession of a controlled substance. The court has granted the state's motion to abandon the enhancement paragraph, follows the plea bargain, sentences you to 3 years in the Texas Department of Criminal Justice with credit for 5 days, and orders you to pay your attorney's fees, court costs, and lab fee. And Mr. Osborne, before you go, have you had an opportunity to review the judgment or conviction in your case?
Yes, sir.
Was your name, the charge, and time credit correct?
Yes, sir.
All right, sir. You're now remanded back to the custody of the sheriff for transport to TDC to serve out your sentence. Good luck, Mr. Osborne.
Rodriguez, page 4.
Lamonte Rodriguez. And what are we doing? The status or plea?
Not plea.
Okay. All right, these are cause numbers CR 21-0065 and 0066-173, both styled the state of Texas versus Lamonte Rodriguez, and both set for status.
Judge, we're gonna ask the court, or I'm gonna ask the court for another status setting. I haven't made Mr. Harrington an offer yet. That's my fault of meaning to, but I haven't. And it may
August
be-
12th.
Sure, that works for us.
Yes, sir.
Mr. Rodriguez, you're all right with me resetting this to August 12th? Well, okay. You're the one in jail, not any of us, so you're all right with that? All right, sir. I'm going to reset you for August 12th at 1:30 for status. And if y'all work something out soon.
Yes, sir. Hutchins, 5-4, wait, 3.
David Hutchins. All right, this is cause number CR 21-0061-173, the state of Texas versus David Hutchins, set for status.
In this case, the state made an offer of 7 years TDC, and I've relayed that to Mr. Hutchins, and he's requesting a trial setting instead.
Okay.
That offer.
All right, then, Mr. Hudson, the court will note that you've rejected the plea bargain. Is this a straight up third?
No, Judge, there's two enhancement paragraphs which make them 25 to life.
Okay, Mr. Hutchins, I know Mr. Harrington's explained to you.
Yes.
But I'm gonna put it on the record that you've got the 7-year offer here, and I presume you're innocent. I don't presume you any other way. But if you do go to trial and you are found guilty beyond a reasonable doubt by either a court or a jury, and you go to punishment, the court or the jury, if the state proved those two enhancement paragraphs true, the court or jury would have no choice but the minimum would be 25. They couldn't get around it. You understand?
Yes, sir.
All righty, sir. Well, then where's he at?
He's in the same situation as Mr. Rockmore. Let's go to see if he makes it or not.
All right, so Mr. Hutchins, don't know where you're at in the top 10 there, but you'll be getting a setting soon. So you'll be in touch with Mr. Harrington.
Mr. Hutchins, we have talked about that possible range of punishment the last few days, correct?
Yes, sure.
And you understand that we've talked about that range being potentially 25 to life.
Yes.
And even after we talked about it length, you still want to have a jury trial.
Yes, sir.
Thank you, Judge.
Thank you. Who else? What's going on?
He wants, they want to go in front of Judge Calhoun.
Let's just give me just now. We're in the middle of the docket. Just give me this minute. Last is Edith.
Yes, sir. We sidebar real quick, Judge?
Yes. I don't know why is this so pressing that we're interrupting the doc. I mean, what is? Well, he said you called and we're coming over, so if it's pressing, I'll hang around.
Judge, if you recall, that body that we had some issues with it as well.
But you're gonna put it on the doc, like, or do you need some time? I'm saying you're not ready yet.
No, I can put on.
So we're doing that right now.
Yeah.
Okay. All right. Who do we got? Oh, is he back there with him? Oh, we're working on the paperwork now. All right, let's go off the record. All right, so the county attorney's office. You weren't disruptive. I just didn't know. All right. Yes, sir. Thank you.
we're asking the court to assess formal punishment at a different date. With the agreement, Judge, CR 2063-173 is 9 years confinement and TDC credit for 475 days served plus court costs. This also comes, Your Honor, with lifetime sex offender registration and a lifetime protective order. We're asking the court to consider CR 2064, 66, 67, 68, and 69. We're also asking the court to consider a indicted online solicitation of a minor out of Denton County. In CR 2065, it's also 9 years confinement in TDC, 475 days credit, attorney's fees, and court costs. There's also a lifetime protective order on this cause as well. And these sentences are run concurrent.
You have the cases being considered in 6-5 on the plea sheet, but you just recited 6-3. So in other words, all your motions to dismiss on your 1245s, they reference defendant was convicted in another cause, CR 0063.
Okay, we're gonna ask the court to consider those in 6-5.
So then what I'll do is I'll just change all these to 6-5.
Okay.
Everything's still here? Yeah, they're just putting in a case that was actually led to, so the one was not led to.
Okay, just making sure.
And that's what I'm doing, Mr.
I'd
Edis. I'm
rather
just
ask
making sure.
than-
All right, so Mr. Edis, is that your understanding of the two plea bargains?
Yes, sir.
And Mr. Harrington, is that your understanding?
Yes, sir.
All right, well, Mr. Edis, a few minutes ago, you told me you could read and write the English language. I'm gonna go over some documents with you. The first is the agreed plea recommendations. I'm showing you one for each case. Did you read and go over those with Mr. Harrington?
Yes, sir.
Both the front and the back?
Yes, sir.
Did you sign the front and the back?
Yes, sir.
The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Harrington?
Yes, sir.
And there's one for each case. They say the same thing. The only thing difference, the cause number at the top. And did you sign the back of each of those for each case? Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with Mr. Harrington? Well, if you read and went over these with him, I know he explained to you that in all of these cases, you have many constitutional rights, including the right to trial by jury.
Yes, sir.
Do you want a jury trial in either of these cases?
No, sir.
Do you want to waive your right to a jury trial and enter into these plea bargains with the
Yes,
state?
sir.
And I'll ask you, sir, how do you plead to that first degree felony offense of aggravating kidnapping in 0063? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes.
And in cause number CR 20-0065-173, to that third degree felony offense of assault family violence, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes.
I'll hear the evidence in each case.
Judge, in CR 2063, I had 2 exhibits. Stage 1's an offense report. Stage 2 is Michael Morton compliance.
Objection.
Admitted.
We rest in that cause. And in CR 2065, Stage 1 an offense report, and Stage 2 is Michael Morton compliance.
Objection.
Admitted.
State rests in that cause. as well.
As to guilt innocence.
As to guilt innocence.
And anything as to guilt innocence, Mr. Harrington?
We rest in both cases.
Okay. All right. Well, Mr. Edis, based upon your guilty plea, well, in cause number CR 20-0063-173, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty. The court will recess this hearing and set it for a punishment hearing on. And sets this for a punishment hearing on August the 3rd at 9 a.m. Now, Mr. Edis, also in cause number CR 20-0065-173, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third degree felony offense of assault family violence. And the court then will recess these hearings, and we will set this for punishment on August the 3rd at 9 a.m. as well.
We're halfway there. I think we're like.
Okay, good.
Thank you, Jess.
Thank you.
Are we done?
Yes, sir. Appreciate y'all hanging out with us all day. Creepy dude right there.